Alrighty, so this is Decent We the People News. Alright, so I'm not an attorney. I'm not going to give legal advice. I may give my opinion at times, but it's just my opinion. Do not take it as legal advice. Okay? This is a educational purpose video. Okay? And never look straight forward, people. Always think outside the box, right? Quit imprisoning yourself. Alright? So, once again, just in case it's hard to see, I'm going to spell it out. From Tamarah, okay? Moore. Alright. A few videos back, I did 12 presumptions, right? That you must rebut. And, yeah, I said, I love this woman, alright? She really went in there. Alright, but there's a couple of things not all, but I would do a little bit different. Okay, but it was perfect for her, and it's probably perfect for y'all. Okay, let's begin to proceed forward on this and maybe learn something.
Okay, so I am putting this on the record because I've been in front of this court like 5 or 6 times, and of those times only once was I not under false arrest and imprisonment. So they forced me to all of the first hearings, the arraignment hearings. And I've said it before, but however, I'm not sure that I completely said it on their record, because when they take me in there, they don't often give me much time to speak, and then they haul me off. Or all of the hearings up until the last one, just before I was released in June. Was it released in June? I think the end of June. It might have been the beginning of July. I'm not sure. Oh yeah, it was the end of June. So I was released the end of June, and at that time, I had only been in 2 hearings where the judge, or maybe 3, it might have been 2 forced and 1 well, I don't say willingly because I was forced, but I walked in there without having been in jail. I came from the house. So, they just shut me off when I'm on video, and then what I imagine is they continue with their private bar guild matter. But this time I'm going in saying, look here, it's all recorded in the county recorder's office in the miscellaneous file. It is matter of public record. I do have a Libra number, and the documents stand, and I'm going to read them on the open record here today. So this is what I'm going to attempt to read. And I don't know how they're going to treat me when this happens. I don't know if the judge is going to say, we're going to do this in a little while and make me come back, because what I'm divulging is very much higher knowledge. It isn't something that many people know, and everyone thinks you're crazy because you do. So here we go. 1, Tammy Marie, the House of Sanders, come on this video and in writing to formally challenge the 12 presumptions of law. By definition, presumption is an idea that is taken to be true on the basis of probability. As a presumption is a presumption on which must be agreed by the parties to be true, then and equally. If one party challenges the presumption to be true on the basis of probability, then all that is required to remove the presumption is a formal challenge to that presumption. The presumption has no standing or merit in fact. A probability.
We're going to pause there for a second for some people that may or may not know out there, right? Now, what she's doing is rebutting the silence acquiescence, okay? And not tacit agreeing to their terms. Okay, this is for some people who don't know out there. Okay, So she's doing rebuttal. That way she's not in silence acquiescence. Okay? And that way she's basically rebutting her tacit agreement. She's saying, I'm not tacit agreeing to crap, y'all. Alright?
Is, by definition, to the extent to which something is probable, the likelihood of something happening or being the case. By definition, then, this is not substantive, as it is only a probability of what may be, and therefore has no substance in material fact. A state court does not operate according to any true rule of law, but by presumptions, color of the law. Therefore, presumptions presented by the private bar guild are not rebutted. They become fact and are therefore said to stand true. There are 12 key presumptions asserted by the private bar guilds, which, if unchallenged, stand true, being public record, public service, public oath, immunity, summons, custody, court of guardians, court of trustees, government as executor and beneficiary, agent, agency, incompetence, and guilt. 1. The presumption of public record is that any matter brought before a state court is a matter for the public record, when in fact it is presumed by the members of the private bar guild that the matter is a private bar guild business matter, unless openly rebuked and rejected by stating clearly the matter is to be on the public record. The matter remains a private bar guild matter, completely under private bar guild rules.
Alright, she paused there a little bit. I'm going to pause there. Okay, so I did a video back, right? Administrative court, in fact, is a bill of attainder. And it's unconstitutional, unless there's a contract. Okay? So we're going to go with this again. There's, since you stay in silence or acquiescence, you agree to the terms of contract. Okay, but administrative law is in fact bill of attainder. They got the same 4 elements. What makes a bill of attainder? Okay, if it acts like a duck, looks like a duck, tastes like a duck, then it's a duck. Alright, I'm Joe. The Spanish word is Jose. So, you can call me a Jose, but I'm still Joe. So, therefore, it stands as fact.
1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of public record, as it is by definition a presumption and has no standing or merit in presentable material fact. 2. The presumption of public service is that all the members of the private bar guild who have all sworn a solemn, secret, absolute oath to their guild then act as public agents of the government or public officials by making additional oaths of public office that openly and deliberately contradict their private superior oaths to their own guild. Unless openly rebuked and rejected, the claim stands that these private bar guild members are legitimate public servants and therefore trustees under public oath. 1. Tammy Marie, the House of Sanders, the undersigned.
Now I'm going to pause here again because I believe this is going to be the last time I pause. Now, for me, okay, she's doing this perfect. But for alright, I would say a sovereign man or free man, and then such name, one of the people, right? Because I'm not a national, okay, nor claim to be. However, I'm going to stand with my inalienable rights. There is a constitution to be able to protect my inalienable rights, okay? If I do not cause harm, damage, or loss to another man or woman, then in fact, I have rights, okay? Because I did not take it from anyone else. So I'm going to stand on one of the people, right? Jeez. Declaration of Independence, right? We the people. Okay, I am one of the people. So I must stand on that behalf instead of as a national or Moors or anything like that. Okay, at this present time. Okay, so some of y'all may want to do this a little bit different, but I want to clear all presumptions, right? So I want them to know that I'm sovereign. Unless you guys are scared of the word, right? Then you just say that you're a free man or a free woman. In this Texas Constitution, it is written, free man. So, you actually use what they have in the state constitution or in all other constitutions, right? So I'm a free man. Family name, blank, blank, blank. Okay? One of the people, where you're clarifying that you're not a person, that you're one of the people. So you got this inalienable right, you're not under contract.
Formally challenge the presumption of public service, as it is by definition a presumption and has no standing or merit in presentable material fact. Three, the presumption of public oath is that all members of the private bar guild acting in the capacity of public officials who have sworn a solemn public oath remain bound by that oath and therefore bound to serve honestly, impartially, and fairly as dictated by their oath. Unless openly challenged and their oaths demanded, the presumption stands that the private bar guild members have functioned under their public oath in contradiction to their guild oath. If challenged, such individuals must, not shall, not may, they must recuse themselves as having a conflict of interest and can't possibly stand under a public oath. 1. Tammy Marie.
Now, I just want to pinpoint this a little bit. So, the intent of shall is, and this has been Supreme Courts and all that kind of stuff, shall is a must. Okay? But these attorneys, bar guilds, bar members, is trying to kind of change these definition words. So when she put this must in there, I'm glad she did that because she's clarifying, right? And just kind of pointing this out to y'all, right? There has been American jurisprudence, okay? Shall means must, but due to the bar members, they're kind of trying to change these definition words. So I'm glad that she used must and not shall and all that kind of stuff, which in general is the same thing by the American jurisprudence. Oh, and I'm not giving legal advice. Okay, do not take it as such. Do your own research. Okay, this is educational purposes only.
The House of Sanders, the undersigned, formally challenged the presumption of public oath, as it is by definition a presumption and has no standing or merit in presentable material fact. 4. The presumption of immunity is that key members of the private bar guild, in the capacity of public officials acting as judges, prosecutors, and magistrates, who have sworn a solemn public oath in good faith.
All right, just for you guys to know, she is magistrates, right? I love that word, right? Because magistrates are the maggots. They're at the bottom of the list. Okay, they're maggots. They're feeding off you. All right, she's brilliant on that part. Magistrates, love it.
Are immune from personal claims of injury and liability. Unless openly challenged and their oaths demanded, the presumption stands that the members of the private bar guild, as public trustees acting as judges, prosecutors, and magistrates, are immune from any personal accountability for their actions. 1. Tammy Marie, the House of Sanders, the undersigned formally challenge the presumption of immunity, as it is by definition a presumption, and has no standing or merit in presentable material fact. 5. The presumption of summons is that by custom, a summons unrebutted stands, and therefore one who attends court is presumed to accept the position, such as defendant, juror, witness, and jurisdiction of the court.
Okay, now we're going to go back with, the officers, okay? And I'm doing this for UT purposes so they don't interrupt it. Officers are executive branch, all right? But when they give you a ticket, that's basically what they're saying is a summons, okay? But officers cannot legally or lawfully give you a summons. They're not a judicial branch, which makes it what? Null and void. But because we say in silence acquiescence and we tacitly agree to their terms, then, like they said, presumptions, right? Stands as facts if you do not rebut it. Okay? So, just to remind you guys, an officer cannot give you a summons, which is what a ticket is. You got to rebut it. Alright? The only way an officer, since they're executive branch, is they must have a warrant and they've seen a crime in progress.
Attendance to court is usually invitation by summons, unless the summons is rejected and returned, with the copy of the rejection filed to choosing to visit, prior to choosing to visit or to attend. Jurisdiction and position as the accused and the existence of guilt stands. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of summons, as it is by definition a presumption, and it has no standing or merit in presentable material fact. 6. The presumption of custody is that by custom, a summons or warrant for arrest, unrebutted, stands, and therefore one who attends court is presumed to be a thing, and therefore liable to be detained in custody by custodians. Custodians may only lawfully hold custody of property and things, not flesh and blood soul-possessing beings. Unless this presumption is openly challenged by rejection of summons and or at court, the presumption stands, you a thing and property, and therefore lawfully able to be kept in custody by custodians. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of custody, as it is by definition a presumption and has no standing or merit in presentable material fact.
Again, tell you guys this, okay? So, we're going to go back into officers again, right? They have probable cause. But once again, they cannot make legal determination. So what is that? It's a presumption, okay? Because they cannot make a legal determination of probable cause. That's the reason why I said in the past, you must let the officers know that you must take me to the magistrate, okay? For the magistrate to decide to make a legal determination that probable cause has in fact occurred, okay? You don't get to sit in jail. Innocent people don't get to sit in jail and wait 48 hours, okay? So there has to be remedy. Okay, you're innocent until proven guilty, people. Not this trickery of words of not guilty. Innocent, not guilty is not the fucking same. Okay? Get that through your heads. And when you make a plea, you're making a claim. Okay?
7. The presumption of court of guardians is the presumption that as you may be listed as a resident of a ward of a local government area and have listed on your passport the letter P, you are a pauper and therefore under the guardian powers of the government and its agents as a court of guardians. Unless this presumption is openly challenged to demonstrate demonstrate you are both a general guardian and general executor of the matter, trust before the court. The presumption stands, and you are by default a pauper and lunatic, and therefore must obey the rules of the clerk of guardians, the clerk of magistrates court. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of court of guardians, as it is by definition is a presumption and has no standing or merit in presentable material fact. The presumption of Court of Trustees, number 8. The presumption of Court of Trustees is that members of the private bar guild presume you accept the office of trustee as a public servant and government employee just by attending a Roman court, as such courts are always for public trustees by the rules of the guild and the Roman system. Unless this presumption is openly challenged, to state you are merely visiting by invitation to clear up the matter, and you are not a government employee or public trustee, in this instance, the presumption stands and is assumed as one of the most significant reasons to claim jurisdiction, simply because one appears.
All right. And this is the reason why you're not supposed to be this particular area right here, right? You don't want to claim you're a resident, okay? Your property, okay? Your land, all right? They're calling you a resident. This is the reason why you do not want to be accepted as a resident, people, all right? Presumptions.
1. Tammy Marie, the House of Sanders, under the undersigned, formally challenge the presumption of Court of Trustees, as it is by definition a presumption and has no standing or merit in presentable material fact. 9. Yes. The presumption of government acting in two roles as executor and beneficiary is that for the matter at hand, the private bar guild appoints the judge magistrate in the capacity of executor, while the prosecutor acts in the capacity of beneficiary of the trust for the current matter. If the accused does not seek to assert their rights as executor and beneficiary over their body, mind, and soul, they are acting as an executor de son tort, or a false executor, challenging the rightful judge as executor. There.
I hate pausing this, y'all, but for YouTube purposes, as well as my beneficiary, right? I just love the way she's nitpicking the words, clarifying the direct intent of these words she is speaking, right? And go back and listen to that, how she really clearly established these words.
4. The judge magistrate assumes the role of true executor and has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged, to demonstrate you are both the true general guardian and general executor of the matter trust before the court, questioning and challenging whether the judge or magistrate is seeking to act as executor de son tort, the presumption stands and you are by default the trustee. Therefore, must obey the rules of the executor, judge magistrate, or you are an executor de son tort, and a judge or magistrate, or magi is usually what I say, of the private bar guild may seek the assistance of bailiffs or sheriffs to assert their false claims against you. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of government acting in two roles as executor and beneficiary, as it is by definition a presumption and has no standing or merit in presentable material fact. 10. The presumption of agent and agency is the presumption that under contract law, you've expressed and granted authority to the judge and magistrate through the statements of such words as recognize, understand, or comprehend, and therefore agree to be bound by a contract or bound to a contract. Therefore, unless all presumptions of agent appointment are rebutted through the use of such formal rejections as one doesn't recognize you, to remove all implied or express appointments of the judge, prosecutor, or clerk as agents, the presumption stands, and you agree to be contractually bound to perform at the direction of the judge or magistrate. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of agents and agency, as it is by definition a presumption, and has no standing or merit in presentable material fact. 11. The presumption of incompetence is...
Okay, so remember all this, y'all. Like family court, CPS, okay? Everything is running off presumptions, right? There has not been any affidavit of anybody standing to be a witness to harm, loss, and damages to any offsprings, right? They're going off presumptions. Now, if they have somebody who's going to stand in court and make these claims, then, you have to work within the guidelines of that, okay? Because now there's a witness and somebody signed an affidavit. But always remember, a lot of these things, and this right here, you can use directly into your CPS case, y'all, because that's exactly what they are doing. But also, always get the name of the man and woman that come to your house, right? Because you're going to file a claim on the man and woman, not on that CPS agency, okay? You're going to file a claim on that man and woman that stands before you, because now you have firsthand knowledge of facts. Everything else behind her and behind the closed doors you do not have. But the lady or man that stands before you, now you got firsthand knowledge of what they're speaking of. And since they're making these claims, right, now you're going to make a claim against them.
The presumption that you are at least ignorant of the law, therefore incompetent to present yourself and argue properly. Therefore, the judge magistrate, as executor, has the right to have you arrested, detained, fined, or forced into a psychiatric evaluation. Unless this presumption is openly challenged to the fact that you know your position as executor and beneficiary, and actively rebuke and object to any contrary presumptions, then it stands by the time of pleading that you are incompetent. Then the judge or magistrate can do what they need to keep you obedient. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of incompetence, as it is by definition a presumption and has no standing or merit in presentable material fact or facts. 12. The presumption of guilt is the presumption that, as it is presumed to be a private business meeting of the Bar Guild, you are guilty, whether you plead guilty, do not plead, or plead not guilty. And it don't matter whether you plead or pled guilty, if you did not have a plea, or you pled not guilty. It doesn't matter. Therefore, unless you have either previously prepared an affidavit of truth or motion to dismiss with extreme prejudice into public record or call a demurrer, then the presumption is you are guilty, and the private bar guild can hold you until a bond is prepared to guarantee the amount the guild wants to profit from you. 1. Tammy Marie, the House of Sanders, the undersigned, formally challenged the presumption of guilt, as it is by definition a presumption, and has no standing or merit in presentable material fact. 1. Tammy Marie, the House of Sanders, formally challenged all presumptions of law, and as one has formally challenged all of the 12 presumptions of law, then the presumption of law formally has no substance in material fact. 1. Tammy Marie, the House of Sanders, will recognize the rule of law when and only when there is the material evidence of that assumed rule of law has some material evidence of substance and presentable material fact. Until then, the search for the rule of law that has some credibility in material fact continues. It is done.
Again, y'all, this was awesome. She did a really fabulous job. Okay, but as non-nation people, all right, we got to still do a couple of little tweaks as one of the people. Okay, and knock out the presumptions and stand as one of the people. Okay, awesome job.
Without ill will or vexation, Tammy Marie, the House of Sanders, the living, for and on behalf of the legal entity, Miss Tammy M. Snyder, the defendant.
Alrighty, there we go, y'all. This is Deuce with People News. Okay, remember, everything I said or do is just my opinion. Alright, do not take this as legal advice, okay? This is educational purposes, and I voice my opinion at times. Okay? Again, this is awesome. I can't say anymore. Alright, bye, y'all.